So what's the difference between a will and estate planning? My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota, and New York City. And today let's take a look at the difference between estate planning and a will, two pretty common terms that you may have heard about, and you aren't necessarily sure which one is which. So when it comes to dealing with legal issues, we tend to have a lot of really specialized words. And so when I meet with new clients or prospective clients, they often have questions about these terms and what do they truly mean. Two of the common terms that we deal with in the estate planning world are estate planning and a will. And a lot of times my clients will ask, what's the difference between a will and an estate plan? The reason is, depending upon what resources you're looking at, these terms can be used interchangeably, and they are definitely related, but they're not always explained the difference between one and the other. So, as a general concept, you should understand that a will is a document that is part of an estate plan. So your will, often called your last will and testament, is the document that says what happens to your assets after you're gone. If you have children who are under the age of 18, your will will also appoint a guardian for them and appoint a trustee to manage money for them, as when they're under the age of 18, legally they cannot inherit assets, and they need to have somebody be their guardian as well as manage money for them. So when people come to my office and say, I need to work on these documents, the most common document they're thinking of is that last will and testament. And don't get that confused with a living will. A living will does have the word will in it as well, but that document is designed for when you're still alive and you may be hooked up to machines and it's commonly referred to as a do not resuscitate as well, a DNR, and that living will say, if my quality of life has gone down or I'm being kept alive by a machine, do I want them to withdraw the life support systems and allow me to pass away? So that's a living will, which is different than your last will and testament. The living will is while you're alive. The last will and testament is what happens after you're gone. On the other side of this question, we have estate planning. And so estate planning is a more generalized term, and it's for all of the different documents that we create for what happens when you become sick or when you die. So in your estate plan, you're going to have various documents like powers of attorney. So a power of attorney, either financial or healthcare, will be a document that is used when you become too sick or you're for some reason unable to make decisions for yourself. That financial power of attorney will allow somebody else to make financial decisions and manage your finances for you. The healthcare power of attorney, on the other hand, will designate somebody to make medical decisions for you. So if you're in a coma or if you're unable to speak for yourself, we want to have a healthcare power of attorney, sometimes called a healthcare directive, in place so we know the right person is making health decisions for you. We also briefly talked about the living will, which would come into play in that healthcare situation where you're unable to make decisions for yourself and maybe you're in a coma and hooked up to a bunch of machines and you no longer want that life support. That living will gives a direction to your family as to when or when you would not want life support to be withdrawn. In connection with your healthcare documents, you also may have a HIPAA authorization. Just like when you go to the doctor's office, when you sign all those forms and check-in, one of those is a HIPAA authorization, HIPAA, and what that is that's health insurance or health information that is being shared with your loved ones or being shared with somebody else. So normally we want the healthcare power of attorney, whoever's operating under your healthcare directive, to have access to medical records so they can make an informed decision if they have to make medical decisions for you. Another document that quite commonly is part of your estate plan will be a trust. So many clients will come to my office with more questions about creating a trust. And there's two types of trusts we can create. One is while you're alive, a living trust, normally a revocable living trust, which means one that you can make changes to while you're alive. The flip side of that is an irrevocable living trust, and in that type of trust you have no ability to make changes. Once you've signed your trust, that's the end of it. It cannot be changed. The other side is a trust that's called a testamentary trust, and a testamentary trust is set up in your will, and it's a trust that only gets created upon your death. This is a more common trust if we have children who are under the age of 18. Maybe they're actually 14 or 15 already, and you're not sure you really need that trust. The testamentary trust can be in place in your will just in case a trust is needed. It's not going to be required, however, if by the time you die your children are over the age of 18. And then of course that final document we're talking about, and we talked about at the beginning of the video, is your last will and testament. Also a very important part of your estate plan. It says what happens to your assets and your distributions after you're gone. If you also have a trust, you will usually have a will that says, if there's anything I forgot to put in my trust while I was alive, then my will transfer it to the trust. So hopefully this has been a simple explanation for you to see the difference between an estate plan and a will. To give you a quick summary again, your last will and testament, your will, is one of the documents in your estate plan. If you have more questions, you want to get started on estate planning, you can go to my website, 𝙃𝙀𝙍𝙀𝙒. There's a red legal strategy session button on the front page. You can click that and you'll be taken to my personal scheduling page. We can set up a 15 or 20 minute phone call to go through where you are in the estate planning process and get your questions answered. If you like this video, you can hit the like or thumbs up button below. You can go over to YouTube or 𝙃𝙀𝙍𝙀𝙒.com to subscribe to future videos. And I hope you've got a pretty simple answer to this very common question: what is the difference between that will and that estate plan?